Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of contempt of court, criminal and succession laws. To know more about them, please watch the video fully. In the important judgment titled Future Coupons Private Limited and Others versus Amazon.com NV Investment Holdings LLC and others, and pronounced on 1st February 2022, the Supreme Court has held that contempt of a civil nature can be made out under Order 39 Rule 2A of the Code of Civil Procedure only when there has been willful disobedience and not on mere disobedience. The facts of the case would be that Amazon entered into shareholder and share subscription agreements with Future Coupon Private Limited. Future Coupon Private Limited and its promoters entered into a shareholder agreement with Future Retail Limited. Dispute arose with regard to sale transaction. Agreed by the aforesaid sale transaction, Amazon initiated arbitration proceedings. Parallelly, a suit was filed before the Delhi High Court against Amazon for tortious interference in the scheme for the sale of assets. The emergency arbitrator and the single bench came to diametrically opposite conclusions. After a very long legal battle, the order of the arbitral tribunal rejecting the vacant petition was challenged by Future Coupon Private Limited and Future Retail Limited before the Delhi High Court. Future Retail Limited also filed interim application with certain priors. By third impugned order, the Delhi High Court refused any immediate relief to Future Retail Limited. Agreed by the aforesaid order, Future Coupon Private Limited and Future Retail Limited approached this court with allegation that the impugned order merits setting aside due to grave injustice caused to the appellants due to the principles of natural justice being given a go-by. No opportunity was granted to filing of any response, which has resulted in various factual and legal errors creeping in the impugned order. The counsel has further submitted that punitive directions could not have been passed even in contempt jurisdiction without affording the party a proper opportunity of filing a reply. The senior counsel appearing for Amazon submitted that the appellants by their conduct demonstrated willful and intentional disobedience of the emergency arbitrator's interim award after agreeing for the emergency arbitrator. The Supreme Court has held that the orders of the single judge are impugned on the grounds of lack of an opportunity granted to Future Coupon Private Limited and Future Retail Limited to file a counter to establish their defense. Natural justice is an important facet of a judicial review. Providing effective natural justice to affected parties before a decision is taken is necessary to maintain the rule of law. Natural justice is usually discussed in the context of administrative actions, wherein procedural requirement of a fair hearing is read in to ensure that no injustice is caused. When it comes to judicial review, the natural justice principle is built into the rules and procedures of the court, which are expected to be followed meticulously to ensure that higher standards of fairness are afforded to the parties. Further, the contempt of a civil nature can be made out under Order 39 Rule 2A of CPC not when there has been mere disobedience, but only when there has been willful disobedience. The allegation of willful disobedience being in the nature of criminal liability, the same has to be proved to the satisfaction of the court that the disobedience was not mere disobedience but willful and conscious. Considering the fact that in the suit instituted by Future Retail Limited, the single judge had earlier allowed Future Retail Limited and Amazon to continue their pursuit before various regulatory authorities, and in view of the interim orders of this court and the courts below, this court is inclined to set aside the impugned directions as the precondition of the sufficient mental element for willful disobedience is not satisfied. Taking note of the submissions, this court sets aside the punitive directions issued in the impugned orders of the single judge. Therefore, the impugned orders are set aside. Coming to the next important judgment, titled State of UP versus Veerpal and Anr, and pronounced on 1st February 2022. In this judgment, the Supreme Court has held that there can be conviction solely based upon the dying declaration without corroboration. The facts of the case would be that the charge sheet against accused for the offences under Section 302 read with Section 34 of the IPC is filed after completion of investigation. After trial, the trial court convicted the accused for the offences under Section 302 read with Section 34 of the IPC and sentenced the accused to undergo life imprisonment. Feeling aggrieved and dissatisfied with the judgment and order of conviction and sentence imposed by the trial court, the accused preferred the appeal before the High Court. By the impugned judgment and order, the High Court has acquitted the accused mainly on the ground that there were two dying declarations and there was a gap of 2 days between the two dying declarations. Being aggrieved, the state has preferred the present appeal with allegation that the High Court has committed a grave error in acquitting the accused for the serious offences under Section 302 read with Section 34 of the IPC, whereas it ought to have relied upon and considered the dying declaration recorded by the competent magistrate. The issues posed for consideration are whether the second dying declaration recorded by the magistrate is to be believed and whether on the basis of such dying declaration recorded by the magistrate the accused can be convicted, and whether in absence of any corroborative evidence there can be a conviction relying upon the dying declaration only. The Supreme Court has held that there can be a conviction solely based upon the dying declaration without corroboration. Facts on record show that although the accused was not specifically named by the deceased in her statement recorded under Section 161 of the CRPC as the person who set the deceased on fire, he has been so named in her dying declaration. Even in the statement recorded under Section 161 of the CRPC, the deceased has stated that her father-in-law had attacked her with a stick with an intention to kill her, and as a result she locked herself in the room and set herself ablaze. Therefore, this court finds that there runs a common thread in the statements of the deceased, being that she was attacked by the accused herein. Further, this court also finds that the statements made by the deceased in her dying declaration are consistent with medical evidence, which reveals that there were burns on all parts of the body except chest and sides of the abdomen and back. The burns are at such parts as could have resulted when a person other than the deceased poured kerosene and set fire. As already noted, if the deceased had set herself on fire, her chest ought to have been burnt. In the light of the aforesaid discussion, this court finds that the medical evidence is consistent with the dying declaration, thereby allowing this court to place reliance on the dying declarations. The trial court has rightly observed as to the weight and reliance that must be placed on the dying declaration of the deceased. There was no reason for the High Court to disregard the dying declaration of the deceased. Further, the trial court rightly placed reliance on the dying declaration, having due regard to the statements made by the physician as to the medical condition of the deceased while making such declaration. The trial court has also rightly noted that the statements of the magistrate and the physician, being independent witnesses in the trial, has added weight to the prosecution case as the same could not be motivated by malice. Therefore, considering the dying declaration recorded by the magistrate, the accused can be convicted for which they were tried. Hence, the High Court has committed a grave error in acquitting the accused. The impugned judgment and order passed by the High Court acquitting the accused for the offences punishable under Section 302 read with Section 34 of the IPC is unsustainable, and the same deserves to be quashed and set aside. Now we are going to deal with the important judgment titled JOGI versus Suresh, Kumar and others, and pronounced on 1st February 2022. In this judgment, the Supreme Court has held that Section 14(1) of the Hindu Succession Act does not bar the bequeathing of a little estate to a female by way of a will. But if the limited estate is given to the wife for her maintenance, then it would mature into an absolute estate under Section 14(1) of the Act. The facts of the case would be that the will bequeathed the testator's estate to his son, the appellant herein, and his second wife Ram Devi, the first wife being deceased, whose progeny is the appellant. However, the nature of bequeath was different for the two. The appellant was given absolute ownership rights to the extent of his share of land and property, whereas Ram Devi was given a limited ownership for her enjoyment during her lifetime with respect to her share of the land, with a specific provision that she could not alienate, transfer, or create third party rights over the same. Thereafter, the property was to vest absolutely in the appellant after her lifetime. Bimla Devi, the daughter of Ram Devi, instituted a suit for declaration against her mother Ram Devi, claiming that she had become owner in possession of half share of the land willed to Ram Devi by Tulsi Ram, which resulted in a decree being passed. On the decree being passed, Bimla Devi executed a lease deed in favor of one Amar Singh in respect of land falling within Ram Devi's limited share. After rounds of litigation, a decree of possession granted to the appellant. The appeal preferred against said judgment got dismissed. That gave rise to the second appeal before the High Court. The respondent succeeded before the High Court. The appellant approaching this court with allegation that the life estate was not given to Ram Devi in lieu of recognition of any pre-existing right of Ram Devi or in lieu of maintenance, and thus Section 14(2) of the Act would apply and not Section 14(1) of the Act. The questions posed for consideration are: in the given factual scenario, did Ram Devi become the absolute owner of the property in view of Section 14(1) of the Act, or in view of the will, the explanation under Section 14(2) of the Act would apply? And what is the effect of the first round of litigation which came up to this court between the appellant and Ram Devi, the two beneficiaries of the will? The Supreme Court has held that Section 14(1) provides that any property possessed by a female Hindu, whether acquired before or after the commencement of the 1956 Act, shall be held by her as full owner thereof and not as a limited owner. Section 14(2) states that nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under a decree or an order of a civil court or under an award where the terms of the gift, will or other instrument or the decree, order of award prescribe a restricted estate in such property. The objective of Section 14(1) is to create an absolute interest in case of a limited interest of the wife, where such limited estate owes its origin to law as it stood then. The objective cannot be that a Hindu male who owns self-acquired property is unable to execute a will giving a limited estate to a wife if all other aspects including maintenance are taken care of. If this court were to hold so, it would imply that if the wife is disinherited under the will, it would be sustainable, but if a limited estate is given, it would mature into an absolute interest irrespective of the intent of the testator. That cannot be the objective in view of this court. The testator in the present case, Tulsi Ram, had taken all care for the needs of the maintenance of his wife by ensuring that the revenue generated from the estate would go to her alone. He, however, wished to give only a limited lift interest to her as the second wife, with the son inheriting the complete estate after her lifetime. This court is thus of the view that it would be the provisions of section 14(2) which would come into play in such a scenario, and Ram Devi only had a life interest in her favor. The national sequitur is that the respondents cannot inherit a better title than what the vendor had, and thus the view taken by the trial court and the first appellate court is the correct view, and the sale deeds in favor of the respondents cannot be sustained. Further, the sequence of litigations can hardly be said to classify the respondents as bona fide purchasers. The first endeavour was by the daughter of the Ram Devi by seeking what is undoubtedly a collusive decree when she had no interest in the property. She then sought to create least interest in the property. Both these aspects were held against Ram Devi and her daughter right till the Supreme Court in the first round of litigation clearly opining that Ram Devi had only a limited estate in the property. Despite having lost right to the Supreme Court, the sale deeds were intervening factors even during the pendency of the litigation went against the vendor Ram Devi. The rights of the respondents are derived only from Ram Devi, and once the judgment is binding on Ram Devi, it cannot be said that she can create rights contrary to the judgment in favor of the third parties, and that too was done during pendency of the litigation. The transactions in question are not only not bona fide but dubious in character to somehow deny the appellant rights conferred under the will, respondents being third parties. The repeated endeavour of Ram Devi and her daughter did not succeed earlier and cannot be permitted to succeed qua the purchasers from Ram Devi. Therefore, the impugned judgment of single judge is set aside and the decree of the trial court as affirmed by the appellate court is reaffirmed.